This is Shinera's webinar on the excuse me. This is the Shinera webinar on dispute prevention and resolution. My name is Judy Mendoza. I am in the Risk Management Department of Victor O. Shinera. My background has been in risk management and also as a director of claims for, or a regional claims manager for an insurance company, exclusively handling claims against architects and engineers. So I have a lot of experience in this particular area. Okay, today what we're going to be discussing are three essential strategies: preventing disputes from happening in the first place, trying to resolve disputes that can't be prevented quickly and at the lowest possible within the organization, and then resorting to binding adjudication only when voluntary, non-adjudicative procedures fail. Just so everybody's on the same page and understands what I'm talking about, an adjudicative resolution means that's a resolution in which a third party makes the decision as to whether or not you have negligence or liability and what those damages are that you owe. We'll talk about that in more detail later. Obviously, the preference is if you can't resolve a dispute informally, then to at least use a non-adjudicative resolution process that gives you the opportunity to maintain more control. Now, the standard form documents, the AIA documents, the EJCDC documents, which is the engineer set of documents, tries to prevent disputes, but recognizes that they should be anticipated and addressed in the contract documents. Non-adjudicative methods, often called ADR or alternative dispute resolution, refers to alternatives to litigation, like negotiation, mediation, a dispute review board. And although arbitration is really truly an alternative to litigation, we're going to address it in the adjudicative resolution section because, like litigation, it's adversarial in nature and results in a binding decision that's imposed by a third party. Okay, so the process of anticipating and preventing disputes begins with your relationship with your client and having the knowledge to recognize when something may be a dispute and what to do about it. The saying usually goes that disputes, unlike fine wine, don't get better with age. If you're noticing that there's a problem with your client, our suggestion is always to address it up front. You don't want to let it fester and get worse. It becomes like a runaway train. If you don't address things quickly, they can get out of control, and then you could end up in litigation. So we're going to try to help you avoid getting to that point. When I say recognizing some danger situations, here's some examples of situations that should probably raise the red flag and make you want to stop and think about whether or not you've got a problem on your hand. One may, for example, be your client's unreasonable refusal to accept your advice about a scope of service or the level of effort required to accomplish the project. It may be your client's unwillingness to negotiate fair contract terms and compensation. The client may try holding you to a standard of care that may be construed as requiring perfection. Examples would be using superlatives in your contracts, for example, requiring the highest standard of care or the best efforts or providing services that are most economical. It's always best to avoid superlatives. They may increase the standard of care and raise your client's expectations. Indemnification provisions that obligate you to indemnify your client for all loss or damage, even if they're partially at fault. These are all danger signs that you may have a problem down the line. Requirements to perform within a certain time frame, even though your ability to meet that schedule isn't entirely in your control. Your client's refusal to accept your advice regarding the contractor's performance. And probably a real big one is your client's refusal to pay you, particularly when services are complete. If your client stops paying you either during the project or when the services are complete, that can be a huge red flag. And we often see that when design professionals initiate litigation against their client to recover their fees, probably 90% of the time the client is going to turn around and present a counterclaim saying, well, the reason we didn't pay you is that your services were negligent or deficient or whatever. And then you're off in a litany of disputes. So it's important to not wait until the project is completed to try to obtain, to have your fees paid. You should have a fee payment schedule in your contract and stick to it. And if the client along the way stops paying you, have a conversation with your client and find out what the reason is. Are they short on money or are they unhappy with your services? And if it's the latter, you need to address it as quickly as possible. Early in the relationship, it's really important to establish an effective method for timely communication. My experience when I was handling claims is that many claims result from a failure of communication between you and your client. Um, I would say the majority of claims really didn't result from a design error because on the whole, you're pretty good at what you do. Yes, occasionally mistakes get made, but more importantly, if your client has some level of expectation that is above the service that you're providing, even if the service that you're providing meets the standard of care, you're going to have an unhappy client. And an unhappy client can result in disputes, and those disputes can eventually result in litigation and claims. And you want to avoid that at all costs because it just gets very expensive. Why do I spend so much time talking about how your client is reacting? I think that this graph is pretty evident. 63% of claims made against our policyholders over a 10-year period were made by the project owner. So picking the right client is essential. And that includes evaluating if you're a subconsultant to a prime designer or if you're a design professional working for a design builder. You need to evaluate who your client is. And we have separate seminars that you can attend on evaluating clients and projects. But I think choosing the right client is really important. If there's any dissatisfaction of the owner, at least 63% of claims, they can trickle down. They may be making the claim against the prime, and even if you're a subconsultant, you're probably going to get involved in the claim. And as a sub, you have less control over managing the expectations of the owner, but you have to try, especially if you see a problem that isn't being addressed by the prime. You need to sit down with the prime, and maybe the two of you together would approach the owner and try to find out why they're unhappy and what you can do. It's also interesting when you look at this chart, 8.4% of claims were made by the general contractor, and 2.5% of the claims were made by subcontractors. And when you add in claims involving worker bodily injury, you're at 78% of the claims, adding the owner and all the contractor claims. And that's a good thing from a risk management standpoint because these are claims from parties with whom you've got some kind of a relationship. There's not much that you can do about claims from other entities, such as non-worker bodily injury or third-party property damage, but you should be able to manage the risk of the parties with whom you have a relationship, and that would be the owners and the contractors. Negotiation of the client design professional contract offers an early and unique opportunity to address a broad range of issues and help foster realistic client expectations. These issues in particular should receive attention. Client requirements. This needs timely, effective communication. Changes need to be documented. It may result in additional compensation and or changes to the schedule. We talked a little bit about the standard of care. The law requires that design professionals meet the standard of other design professionals practicing at the same time in the same locality on similar projects. It does not require perfection. The law does not require you to warrant or guarantee your professional services or the work of the contractor. So it's very important that your contracts with your clients have an appropriate standard of care. Indemnification should be limited to a failure to meet the standard of care. And, one of the things that you can do when you get a very broad indemnification from a client is to explain how their indemnification may conflict with your professional liability insurance. Professional liability insurance provides coverage for damages to the extent caused by your negligence. So broad indemnifications that aren't limited to negligence are probably going to result in no insurance coverage, and that doesn't really benefit your client. Your client wants to have access to that pot of money that's sitting in your insurance policy. So if you can try to negotiate it and by explaining that it's to their benefit to have an insurable indemnification, that entitles them to the insurance money should your services be provided in a negligent manner. Performance schedule, you should not have responsibility for delays that are outside your control and without your negligence. Try to stay away from things like time is of the essence provisions, because that makes the schedule the most important thing and could result in any slippage of the schedule, resulting in possibly your termination or delay damages, even if they're not based on your negligence. Completeness of construction documents. No set of documents is ever going to be 100% complete and accurate. And clients need to understand that. There are always going to be RFIs from the contractor. There are going to be some ambiguities. No client would ever pay you for a 100% complete set of documents. And I've never seen one in the 30 years that I've been working with design professionals. Clients need to understand that. Cost of construction, you have no control over the cost of labor, materials, or equipment. So there has to be a need for contingencies. Clients have to understand that there may be additional costs that come up, and that, again, does not mean that it's your fault. So they should be prepared for that. It's kind of that good bedside manner. Doctors do that better. If you're prepared for what's going to happen, it's not as jarring when something unforeseen does occur. And in construction and design, there's going to be a lot of unforeseen events happening. You want your client to know that you're on their side and you're working with them, not against them. Construction means and methods. Determine during construction if the work, when completed, will conform to the contract documents, but you should never accept responsibility for construction means, methods, and job site safety, unless, of course, you are acting in a role, say, as a true construction manager or general contractor, but then those exposures would be covered by insurance other than professional liability coverage. So that's kind of outside the scope of what we're talking about today. Compliance with the work. Again, there should be no guarantees by the design professional of the contractor's work. Your observation does not relieve the contractor of their responsibility. And delays in differing site conditions. It's only fair to allow the contractor relief for unanticipated or uncontrollable events or conditions that affect the time or cost of project delivery. So it's important to be proactive in the client education process. Don't accept unfair and unrealistic contract terms. Sometimes you're probably going to do so if you really want to obtain the client's business, or you want to please the client, or it's just a project you've always wanted to work on. But these accommodations simply avoid or defer the problems underlying the client's unrealistic expectations. So be proactive as far as trying to prevent claims from happening in the first place. All of your firm employees should be informed about risk management principles and concerns, not just a few principles. Lots of people in your firm, especially the larger your firm is, the more people are out dealing with clients, and they can unintentionally increase those expectations. And you want to make sure that they understand the realities of what they're saying and how it can impact the client's interpretation of the services you're going to be providing. Marketing representatives, for example, can realistically represent the firm's capabilities. Contract negotiators have to understand the contract terms and the insurance that you've got to back up those terms. And performers of services manage the client's expectations and identify and respond to problems. We have a lot of information that can help you. We have the Schinner School of Risk Management, which has a ton of information. We'll talk about that more a little bit later. But educate your staff. We can help you set up training programs for your staff. Management oversight. If it's appropriate for the firm size, you should have a dedicated risk manager. Management at all levels should encourage identification of potential problems, establish contract terms and conditions, limit contract negotiations to just a few key personnel. You want to ensure that your clients are billed in accordance with the contract requirements. We already talked about some of the problems that can ensue if your client isn't paying you and you try to recover those fees. That can often result in claims. Monitor receivables. Again, failure to pay is a leading indication of client dissatisfaction. So the interaction between the management and your professional staff when the client problems arise introduces objectivity and helps resolution. Don't blame the bearer of the bad news, but you want to encourage all of your staff to be able to come to you and let you know if there's a problem with the client without, taking it out on them or being judgmental. Work together to proactively figure out why is the client unhappy and what can you do to smooth over the situation so you don't end up in disputes. think ahead. For example, if you're working on a project that's a publicly bid project, we know from experience that bidders, contractors, have a reputation for lowball bids. Uh, they know that they're only going to get the job if they're the lowest bid possible, and they go to seminars like this and they learn how to try to make up for the money that was left on the table. So you want to assign a skilled project manager to educate and prepare the client for the possibility of contractor claims. And if you're working on a project such as a publicly bid project, a lot of school projects, for example, you need to stay on top of the contractor, respond in a timely manner to contractor inquiries, and document. Um, you know that there's a better chance you're going to have claims on those kind of projects, and the more you can do to stay on top of it and document it so that if a dispute does arise, your attorneys and your claims people have documentation that can help defend you, to show how responsive you are and to show perhaps how they were increasing the number of questions on the project just to make it look like your documents were incomplete, even if though they probably were not. Um, Partnering and dispute review boards. Partnering is a process. It's not a single event. It's an ongoing effort to develop and maintain communications and relationships between all of the stakeholders on a project. I've been involved in a couple of partnering sessions, and I think they can be very productive in helping the parties come together early on and possibly identify what might be the rocks in the road on this project. I mean, as an example, one partnering session that I was involved with was for a hospital project that was in a residential neighborhood. And so the group together came up with the thought that all of the construction materials and trucks that were going to be going through the residential neighborhood could be upsetting to the neighbors, and that could result in problems. So to be proactive, they set up a staging area where all of the trucks would assemble and then would try to make one trip to the project site, perhaps, at a certain, in the middle of the day, not early in the morning or whatever. But they thought about what could be a problem and tried to come up with ways to resolve those issues. Dispute review boards, and we have a whole separate webinar on that topic as well if you'd like to go search for that in the School of Risk Management. That's where a panel of impartial professionals are formed at the beginning of the project and follow the construction progress and encourage dispute avoidance and assist in the resolution of disputes during the construction process. DRBs is really the only alternative dispute resolution process in construction that includes dispute avoidance. And statistics have shown that 98.7% of projects were completed without the need for subsequent dispute resolution methods. So having this dispute board in place on a large project, and these tend to be large projects, but they don't have to be. They can even be smaller ones where maybe you only have one dispute review person as opposed to a panel of three. But if they're on top of what's happening and they manage problems and disputes as they arise, and hold hearings and make decisions and recommendations. As I said, it's been like only about less than 2% of claims and those kind of projects go on into some kind of like arbitration or litigation, which is a really good percentage. Okay, so now let's talk about non-adjudicative dispute resolution. There's a variety of ways that parties can resolve a dispute without resorting to adjudicative processes. So we're going to look at negotiation and mediation, as well as a number of job site techniques, such as the design professional being the interim decision maker, standing neutrals, and dispute review boards. Okay, at the project level, these represent a continuum of dispute resolution techniques. So, for example, if direct negotiation is unsuccessful, the next step may be mediation. And if mediation fails, then the parties most often resort to arbitration or litigation. It's important to note that each step along the way represents not only an escalation in the dispute, but also an escalation in the time and cost necessary to resolve the dispute. So, the most you can do to resolve it at the lowest level is certainly beneficial. CNA offers pre-claims assistance as long as there is no claim, and a claim is defined as a demand for money or services. But again, you may be working on a project where your client isn't paying you, or the contractor and the owner are in dispute over some alleged delay claim by the contractor. Nobody has brought you in yet to the claim or the lawsuit. Nobody said that it's your fault, but if you're aware that there are these kind of problems on your project, that's a really good time to report it to CNA as a pre-claim assistance matter where they can give you advice on how to proceed, how to document what's happening. They might even hire an attorney to assist you, especially if you've perhaps received a summons for a subpoena for your documents or a subpoena for a deposition. You don't want to do all of that yourself. You want to have an attorney help you. And as long as there's no claim, your deductible doesn't apply and CNA would be picking up the money, any payments for that. It's a very good method for helping resolve disputes before they blow up into anything. And it's important to also note that when you report a pre-claim situation, it does not impact your renewal premium. You can have as many pre-claims as you want on a project, on your policy during a policy year, and the underwriters are not going to increase your premium because of that. If anything, I think they might look at that and say, well, this is a proactive insured who is concerned about managing their risk, and that could work to your advantage as opposed to working to your disadvantage. Now, if there is a claim, the demand for money or services, that you must report promptly to your insurance carrier in accordance with the claims notification provisions of the professional liability policy. So as you can see in this graph, the majority of claims are settled by negotiation or mediation. That's like 57% of claims, with the next largest amount being settled during adjudication. That's 20%. And what that means is that a suit or an arbitration has been filed, but the claim was settled before a decision was made by a third party. So the parties still have some control. As we later discuss adjudicated dispute resolution, keep in mind that only 6.3% of claims are settled by a verdict by trial and less than 1% by a verdict in arbitration. And I think you'll soon understand why those numbers are so low. So let's talk first about negotiation. I'm sure many of you have heard of this book, perhaps have read this book, Getting to Yes, Negotiating Agreement Without Giving In. In my opinion, this is the Bible for negotiation techniques. I think it's a brilliant book. It can work in a variety of situations. We have, again, other webinars available on negotiation, so this is going to be a very brief introduction. But I urge you to read the book and or watch our webinar on the subject. I think the lessons are very valuable. So the book Getting to Yes basically promotes what's known as interest-based bargaining as opposed to positional bargaining. Positional bargaining is characterized when the parties exaggerate their respective positions in order to meet somewhere in between. And this typically favors the party with superior leverage, so it's not really very productive. An example of this is you go into a negotiation and your client says, I want $1 million, and you offer $10,000, and then maybe you meet somewhere in between that. That's kind of positional bargaining. Interest-based bargaining, which is also known commonly as principled negotiation, advocates that the parties pursue 4 strategies that are applicable to nearly every situation. And those are the ones in the bubble on the slide. First, separate the people from the problem. You want to try to see the problem objectively and avoid reacting personally and emotionally. It's just a way of kind of reaching out to the other party, making friends with them, and trying to work in a non-adversarial position. Focus on the interests, not the positions. The problem with focusing on position is that it stifles creativity and harms relationships. A position is something that you've decided upon. It's like sticking to your guns, whereas the interest is what caused you to reach that decision or that position. So when you're negotiating, what you want to do is look for the position for motivating interests. What caused that person to have that demand against you? And focus on what that interest is, which may be very different from, it may open their eyes to realize that what they're demanding is not necessarily what they want or what they need. Generate a variety of possibilities before deciding what to do. Brainstorm together. Develop a number of possible solutions. There's a better chance you'll find one that suits the needs of all the parties. And insist that the results are based on some objective standard. Objective standards can include everything from expert opinions, custom, law, professional standards, technical specifications, or the general conditions of the construction contract. But finding external standards persuades others that they're being treated fairly and protects us from feeling like we're being ripped off. Again, this was a very brief introduction to the concept of interest-based negotiation, but I hope it was enough to whet your appetite and maybe look at our webinar on negotiation. So putting it all together, following these steps will ensure that agreements help build strong working relationships. Because keep in mind, when you're negotiating with your client on something, this isn't like buying a car, which is a one-off. You can go in and negotiate hard to buy that new car for yourself from a car dealer, and that's probably the only time you're going to be dealing with that particular person, right? But when you're dealing with your client on starts with negotiating your contract, then it might be a change order or an issue with the contractor. There are going to be many negotiations. So you don't want to burn bridges. You want to have a smooth relationship. Things will go better and the whole project will be better if, all of those negotiations are somewhat built on a strong relationship. You want to make sure that you've reached this efficiently through effective communication. You want to satisfy your interests as well as the interests of the other party. You want an elegant solution that encompasses the best of many options. You want it to feel legitimate so nobody feels that they've been taken advantage of. And you want the negotiated event to be better than your alternatives. That's what's something known as the BATNA, B-A-T-N-A, which is the best alternative to a negotiated agreement. Basically, you want the settlement that you reach to be better than your alternatives, which is the BATNA. And you want to result in a commitment that is well-planned, realistic, and operational. Now, some of the job site techniques that are available, these three methods are typically built into the project delivery process, and they're designed to facilitate dispute resolution in a manner that's more contemporaneous with the actual activities on the project. So they're often used when direct negotiation has failed. The first one we'll talk about is the design professional as the interim decision maker. During construction, under the AIA and the EJCDC documents, the design professional serves as the client's rep and also as the impartial interpreter of the requirements of the contract documents and as the initial arbiter of disputes between the client and the contractor. This can be controversial because, let's face it, the architect or the engineer isn't really neutral. They're usually working for the owner of the project. But the AIA documents allow the owner to select you either as the decision maker or select an initial decision maker other than the architect. A standing neutral is a third party appointed to stand ready to resolve disputes on short notice. Should be involved with the project from the beginning. They should be somebody who's experienced with design and construction, and someone who has the respect of all the parties. That will make it easier for their decision to be adhered to. Opinions can be binding or non-binding. Most typically, they are not binding, and expenses are typically shared by the client and the contractor. Then there's the dispute review board, which we've touched on briefly. They've proven to be very successful, especially on these large projects. Like a standing neutral, they're established prior to the start of construction. They convene regularly during the project. They have firsthand knowledge of the events giving rise to the disputes, and they have experience with the types of construction involved. Typically, there's 3 members, and they encourage resolution of disputes at the job level. So they identify and discuss issues before they become disputes. DRB submission of disputes to the DRB is mandatory, and the written recommendations of the Design Dispute Review Board are non-binding, but are admissible later in arbitration or litigation. And again, expenses are shared by the client and the contractor. 58% of the projects were dispute-free, meaning that there was no DRB hearing required. And as I said earlier, 98.7% of the projects were completed without the need for subsequent dispute resolution methods. Now, many of you are probably familiar with mediation. Again, it's unlike an adjudicated dispute resolution. You have control over the outcome. Mediation is typically informal, it's non-binding, and in my experience, I've personally probably attended over 200 mediations on different claims, and in my experience, they were successful probably about 85% of the time, which is a pretty good number, I would say. For mediations to work, it's important to select the mediator carefully. You want to have a mediator who is well qualified, has a good reputation, and most importantly, is really knowledgeable about the design and construction process. You want to be sure you have the right parties attend the mediation and that those parties have the authority to settle. Otherwise, it can be a giant waste of time. And the parties have to participate in good faith. So what happens in a mediation is typically the mediator conducts a joint meeting. Um, each party has a chance to put forth their position. The plaintiff would put forth what their claims are and why they feel they're entitled to these damages, and then each party would probably explain why they don't think they're responsible for the damages, or if they are, it's probably a smaller number. The mediator's objective is to help the parties identify, clarify, narrow, and remove barriers to a mutually satisfactory negotiated settlement. A good mediator will often act as an agent of reality, pointing out holes in your arguments, reminding you of the cost and the time of alternatives such as litigation and arbitration. And the one thing I found about mediation that I loved is that it was very educational, even if the claim didn't settle. There were many times I went into a mediation thinking I understood what our position was, and after listening to, let's say, plaintiff's experts present their evidence, it might make us reassess what our position is. Sometimes it makes you feel like you have a stronger case, and other times it may make you feel like you have a weaker case, and maybe you need to increase your authority or your reserve and your authority and consider a higher settlement. And with mediation, it's best and typical if the costs are shared equally by all the parties so that everybody has an equal stake in the mediation. Adjudicative dispute resolution, let me go back to that, is resolution that's imposed by a third party. Typically, this involves arbitration and litigation, and we're going to look at the processes, the terminology, and the strengths and weaknesses of both, and what aspects can be controlled by contract. There are a lot of things that need to be taken into account here. So I created this wonderful chart, and when I first showed it to my boss, she said, "Wow, don't you think that's awfully confusing? Are you sure you want to use something like that?" And I said, "Thank you. That's exactly what I was trying to get across." Because what I was trying to show in this is how incredibly complex and confusing it is to be involved in litigation. So let's kind of start with talking about the terminology and who all the parties are. It starts with the plaintiff. The plaintiff, in most cases, as we've seen, in 63% of the claims against design professionals, are going to be the project owner. So let's say in this instance, the plaintiff is the project owner and the plaintiff, has the claim for whatever. So a lawsuit typically starts with a complaint filed by the plaintiff against the defendants. And it contains causes of action, which are the facts according to the plaintiff, their theories of alleged liability, and the damages that are incurred. A summons is served on the defendants, and the defendants have a limited time to respond. This is very important to understand. In most jurisdictions, once you're served with a summons, you have 20 or 30 days to respond to it. If you fail to respond, the other party can possibly take a default judgment, which means you don't get a chance to defend yourself, but a judgment is entered against you and you would have to pay it. You don't want to be in that situation. So whenever a lawsuit comes in, and everybody in your firm should understand the importance of that, you need to raise it to the highest person in your firm and you need to report it to your insurance company immediately. I can't stress that enough. Now, very often there's more than one defendant in a claim. There can be co-defendants. Very typically, in a construction defect case, the owner is going to make claims against the contractor and the design professional, and they would be the defendants. As you can see in this, so let's say as the design professional, you've been served with a complaint by the plaintiff. Typically, the co-defendants will file what's known as cross-complaints against each other, kind of saying, we don't think we're liable, and we think the other party is responsible. So there's some finger pointing there. There also could be counterclaims filed. if you look at the little arrow on the right side, that's where the prime designer says, not only do I not think I'm responsible, but you still owe me fees. So I'm filing a counterclaim against you, Mr. and Ms. Owner, for the payment of fees that you owe us. Now, it doesn't end there. The defendants are going to probably want to bring in other parties, and that's known as filing a third-party complaint against third-party defendants. So for a prime designer, they would probably be filing third-party claims or complaints against subconsultants. If it's an architect, they might want to bring in the structural, mechanical, the electrical, the acoustical, whoever they retained. And the same thing on the contractor side. The contractor is going to file third-party complaints against their various subcontractors. And we know how many subcontractors can be on a large project. I have gone to mediations involving, that have occurred after this litigation, and you can have, 30, 40 parties and all of their attorneys and all of their claims representatives in there. You could have 200 people in a ballroom of a hotel, and it's not a fun ballroom. You're not getting cocktails. You're just sitting around and waiting for your turn to talk to the mediator and explain what your position is and, why you don't want to pay any money or how much money you are willing to pay. They are very lengthy and confusing processes. Okay, so getting back to when you're in litigation, after all of these complaints and cross-complaints and third-party complaints are filed, next comes what's known as discovery. And that allows each party to learn the strengths and weaknesses of the other party's case, including what their witnesses are saying and their expert witnesses, and what documents exist. This reduces surprises during the trial, and it will start with interrogatories, which are written questions submitted by one party to another party. They're drafted by attorneys, but the parties help the attorneys with the content, and there can be over 200 questions in a set of interrogatories. Now, if interrogatories are served on you, then you're going to want to sit down with your defense attorney and determine which questions, they are allowed to have answers to. Just because they ask something doesn't necessarily mean you have to respond. So that's going to be a whole process of you meeting with your attorney and helping the attorney also respond to those questions. You might receive a notice to produce or a request for production. That's a request to look at each other's records. Again, plaintiff attorneys tend to issue very broad requests for production where they basically will send something to you saying, we want to look at all of your records related in any way to this project. And you and your attorney will work together to try to narrow that scope so that you're not giving them everything, but you're going to give them what they are entitled to receive. And your attorney will want to go through it too to see if there are any smoking guns in there that they should be aware of. Then we get to the point of something called depositions. And that's where one party's attorney orally questions various individuals with knowledge of the facts of the suit. This can be a very long and expensive process and can take years, months, or years. I don't know if any of you have ever sat through a deposition. I have had mine taken once or twice. It is not a fun process. There are times I wanted to reach across the desk and strangle the attorney who was asking me questions because I felt like I'd been asked the same question 5 different times, in 5 different ways, but it was all the same question. But you have to just kind of bite your tongue and get through it. Okay, and then at some point prior to it actually going to trial, the defense, maybe it's you and your attorney, might file something known as a motion for summary judgment. That's basically a motion that says there's no legal basis to go to trial, and we want to be dismissed from the lawsuit. That may not be granted if there are any disputed facts that can be determined only at trial. And as previously stated, most cases settle prior to trial through a settlement, which is a compromise among the parties where they agree among themselves and avoid the need for an adjudicated resolution. This may happen at a settlement conference, which is ordered by the court. And a lot of jurisdictions, depending on the type of litigation, also will have mandatory mediation where you have to go and talk to somebody as a mediator to try. The courts want you to settle these claims before you take up their valuable time in trials that can go on for weeks and months sometimes. Keep in mind when you do settle, a settlement is not an admission of guilt or liability. The plaintiff voluntarily dismisses the suit against you, and so the defendant has been sued but has not been determined to be liable. So there's a lot to be said for settling as opposed to having that published verdict that is open to the public. Now, there are certain things that you want to think about when you're in litigation, something that you should be determining perhaps even in your contract before you get to that point. So if the case doesn't settle, then it proceeds to either a bench, what's known as a bench trial, or a jury trial. A bench trial is where the judge decides the facts and the application of law. And a jury trial, we're familiar with that. That's where the jury renders a decision based on its perception of the credibility of the information presented by the parties. So what's best, a judge or a jury? Very often you might see in contracts, I review a lot of contracts for our policyholders, where the client wants you to waive a trial by jury. This is opinion, and I've talked to a lot of attorneys, and I think they may all have differing opinions. I think many attorneys, though, who represent design professionals have told me and have written articles about the fact that they may prefer a jury to a judge in construction defect cases. Yes, it's a complicated situation that they're afraid a jury may not understand, but that doesn't necessarily mean a judge can understand it any bit better either. Some things to think about is that you get to choose the jury, but you don't get to choose the judge. So in a jury, you can dismiss potential jurors that you don't think would be fair or reasonable. Also, design professionals typically make good witnesses. They're liked by the juries. So that helps in your favor. Also, when you're dealing with a jury, it's not uncommon that some evidence is going to be excluded so the jury doesn't hear it. Judges, however, hear everything. I would not recommend having a jury if it's a bodily injury case, because juries can tend to be very sympathetic. If somebody is injured, even if sometimes it's not your fault at all. This can happen a lot. We see it with engineers who design highways. There are a lot of claims involving automobile accidents that can involve fatalities or serious injuries. The driver of the car may be drunk or speeding or both, and may or may not even have insurance, or if they have insurance, it's probably minimal insurance. And sometimes there's nobody else to go after except the engineer who designed the road, because the state or the county that owns the road may have immunity because of sovereign immunity. So we have seen cases where the engineer is the only viable party, and even if the engineer did nothing negligent, a jury may end up wanting to award damages just because they feel sorry for the passengers in the car who were innocent victims and are severely injured, as an example. Those are cases that you might want to settle without letting the judge or the jury make that decision. Bench trials, having the judge do it, are typically shorter and less expensive. Judges may or may not be easier to educate, may or may not be more patient listening to all the expert witness testimony. So those are just all things to think about. If you have a contract where your client is asking you to waive a jury trial, I would suggest trying to negotiate not having that in your contract. You may agree to have a judge trial, but I think it's certainly better to make that decision when the actual lawsuit has been served and you know what the claim is about and who the defendants are and what your chances are, and then decide what would be better for you, a judge or a jury. Another thing to think about is the venue. Parties to a contract can designate the geographical area in which a court may hear the case. Most often, it's the state where the project is located in. And that's really what we would recommend having, where it should be. But sometimes clients want it in their backyard. If you're dealing with a large multinational client who's very strong and powerful, I often have reviewed contracts where even the project is in one state, but the client is in a different state, and they want the litigation to happen in their state. There are a lot of reasons for that. For one reason, it might be it's just more convenient for them to have their team of attorneys right there where they can handle it. Maybe they know that the juries in that particular jurisdiction are more amenable, especially if it's, they're being, sometimes a plaintiff can be hometown. You come in from another state, the jury who's local may be more sympathetic to a local owner or a project or county if it's a claim by a government entity. What you should do is discuss with your attorney and make the determination based upon the differences in state law And issues such as statutes of limitation, statutes of repose, concepts of negligence. Some states have pure negligence, some have comparative negligence. You need to know what the law is if they're in the state where this lawsuit may occur. Um, there are differences in how they interpret indemnification provisions and limitation of liability provisions. And very importantly is the generosity of local juries. Your attorneys will know which jurisdictions tend to be generous and which ones are not, which ones are very liberal when it comes to handing out, plaintiff verdicts and which are not. So before you, decide on a venue, especially if it's a venue other than where the project is located, again, something you should talk to your attorney about. And then there's the issue of prevailing party. At the conclusion of the trial, a judgment is entered which the prevailing party can enforce. And I'm going to tie this back to prevailing party provisions that are often also found in contracts, where you'll often see a provision that says the prevailing party shall be entitled to recover all attorney's fees and costs from the non-prevailing party. And there are some issues that you should think about before you agree to sign a contract with a prevailing party provision in it. One of the issues is, how do you sometimes determine the definition of who is the prevailing party? I looked up definitions, and one of them says that one of the parties to a suit who successfully prosecutes the action or successfully defends against it, prevailing on the main issue, though not to the extent of his original contention. So what does that mean? Let's say you have a situation where your client has made a claim against you and they've demanded $1 million. And you say to the client, okay, maybe we've made some errors here and there was some negligence, but the damages aren't any more than $10,000. We'll offer you $10,000. The client refuses to take the $10,000, sues you, goes all the way through depositions and trials and the jury verdict, and comes out against you with a verdict for $10,000. So who prevailed in that case? It could be argued that your client prevailed, and now owe not only the $10,000 verdict, but also all of because contractually you've agreed to pay all their attorney's fees and costs. And the problem with having done that is that under American law, each party pays their own fees and costs, unless there's a contractual promise that changes that. Professional liability insurance policies, because this is a contractual promise that you've made, it's not something that is normally covered by the law, will not pay prevailing party costs. So this could be something that comes out of your pocket. Now, some policyholders like to have a prevailing party provision because they feel it can be, something to negotiate with a client. If a client comes after you for a nuisance claim, you can show them the prevailing party provision and say, this is a nonsense claim, and if you continue to come after me, I'm going to go after you for all my costs and fees. That can have a chilling effect on claims against you. But it can also work on the other side, where you might end up having to pay damages that are not covered by insurance. Now, if those attorney's fees and costs are granted by the court as part of the damages, and you're found to be partially or fully negligent for those damages, then your professional liability insurance would pay for those damages. But if they're not, and the only reason you're having to pay them is because of the provision in your contract, that could be problematic. Just something, again, to consider and talk to your attorney about before you enter into that agreement. Arbitration. Arbitration is an alternative to litigation. The parties agree to have an arbitrator or a panel of arbitrators rule on the merits of their claims. The parties have to agree on the rules for selecting arbitrators and the arbitration process. And there are organizations out there such as the AAA, the American Arbitration Association, which provides standardized rules and panels of pre-qualified arbitrators and will administer the entire arbitration process. So arbitration is similar to trial, but it's conducted in private, it's less formal, and the rules of evidence are relaxed. That can all be good and bad. Okay, the terminology changes a little bit. They call the person who's bringing the claim is not a plaintiff in arbitration, they're called a claimant. And the person who's defending the claim is not a defendant, but is a respondent. There are a lot of differences between litigation and arbitration. And it really is preferences to, again, which one you and your attorney think might be best for a particular case. An arbitration award is final. Let me go back to some of the differences between arbitration and litigation. In litigation, you don't have to pay for the judge, but you do have to pay for arbitrators. That's something to keep in mind. Judges' decisions are constrained by statutory and case law, and the trial is governed by established rules of evidence. Arbitrators don't have similar constraints and may consider whatever evidence they want, including evidence that would be excluded if it was in a trial. So as a result, decisions are sometimes reached that may not be consistent with the law. An arbitration award is final and binding, with a very limited right of appeal. You can really only appeal an arbitration award if you could prove like fraud. Even if it was based on bad law, and you justifiably should not have to be paying that claim, if the arbitrator's decision says you're paying it, you can't appeal it. You're going to have to pay it. Whereas if you're in court, there's the ability to have a decision by an appellate court, which is an important procedural safeguard. So when you go to trial, you can, if you don't like the verdict, you can always file an appeal and hope the appellate court might change the decision. Arbitration, again, is typically final. So for design professionals, defenses based on statutes of limitation or statutes of repose, or sometimes even the professional standard of care, tend to be more successful in litigation. Also, although arbitration was created as an alternative that's supposedly faster and cheaper than a trial, it can, in many cases, be more expensive and take longer. Many defense attorneys that I've talked to urge clients to opt for litigation rather than arbitration in their contracts. So briefly looking at some of the pros and cons of it. The advantages. In most situations, arbitration is faster and cheaper than litigation. Arbitrators usually understand complex technical issues better than judges or juries, because members of the AAA panel of arbitrators have to have a minimum of 10 years construction industry experience, and attorney panelists must devote at least 50% of their practice to construction matters. So you're getting people who do understand the process. And unlike litigation, arbitration is a private process, and hearings can be conducted almost anywhere that's agreed to by the parties. But some of the negatives of arbitration is that the arbitration of complex construction disputes may not be faster or cheaper than litigation. Arbitrators have a tendency to what's known as split the baby, apportioning some of the liability to each party. This approach reduces the chance of obtaining a complete defense verdict. There's a better chance of obtaining a complete defense verdict if you're in litigation. And litigation has clear procedural requirements to protect the parties, such as full discovery, rules of evidence, and appellate review. Such protections are not present in arbitration. So you and your client should carefully consider whether an arbitration provision should be inserted into the professional services agreement. The early decision is critical because once incorporated, the parties are bound to arbitrate at the demand of either party. Conversely, in the absence of a specific agreement to arbitrate, litigation will be the final and binding method of dispute resolution. And while it's true that parties without an arbitration provision can later agree to arbitrate a dispute, that really rarely happens. There's little empirical data available to accurately compare the time and cost of arbitration versus litigation. So a lot of this is based on personal experience. My preference would be similar to what's in the EJ-CDC documents, and that would be to perhaps limit arbitration to claims that are under a stated dollar amount. For example, claims under $250,000 will be arbitrated. If the claim is above that amount, it would go to litigation. I think that might be a good compromise. So let's kind of look at this ADR continuum. Again, remember, if you're insured through the Schinner or CNA program, you don't need our consent to decide which method of dispute resolution to include in your contracts. However, once a claim is made, then consent is required. Once you're involved in a claim, any agreement as to dispute resolution must be discussed with your claims representative and your attorney. The ability to defend against a claim is dependent on prompt investigation and the availability of project documentation. Remember, if you're served with a complaint, report the claim promptly, gather your documents, don't volunteer any payments or make any statements, don't admit any liability or assume any obligation or incur any expenses. We have a separate webinar also on how claims are handled, and it goes into a lot more detail about the appointment of defense counsel, identification of coverage issues, settlement considerations. This webinar was intended to discuss the dispute prevention and differences between the various methods of dispute resolution. And I think if you look at this chart, you can see at the top left in the green, there's negotiation. That is the most preferred way of resolving disputes. It's the cheapest, the fastest, and maintains your good relationship with your client. As you can see, you have the most control over things when you're negotiating. And then it kind of starts sliding downwards towards that red, where, probably the least desirable is a bench or a jury trial. So keep in mind this continuum of alternative dispute resolutions, and most importantly, try to prevent disputes from happening in the first place. For more information, we urge you to visit our website. This is a look at our new website, the Schinnerer School of Risk Management. You can view claim studies, management advisories, contract language and commentary, and past webinars, which are now even eligible for getting more continuing education. So I want to, at this point, thank you for attending, and I am going to stop recording this.